That's great. I think that we should start now because we've got a lot to get through today. So good afternoon, everyone. Welcome to the latest in our series of winter webinar series. Today's webinar is entitled, as you can see, Where Will the Golden Thread Lead? The Draft Building Safety Bill. And we're delighted to have so many attendees today. My name is Michael Salau. I'm a partner at Beale & Co. And I'm joined today by Nathan, Modell and Joanna Lewis, who are also both partners at Beale & Co. Perhaps you could add that slide, please, Gemma. Both Nathan, Joanna and myself are all partners in the dispute and insurance team at Beale & Co. and also deal with regulatory work. The three of us, along with a number of other fellow partners, have all been instructed in high-profile professional negligence fire safety matters. As today we have a large number of attendees who don't usually attend Beale & Co, please bear with me. I just want to say a few things about Beale & Co for those who don't know us. We're a specialist law firm in the field of international construction and insurance law. We've been providing advice relating to complex projects and disputes around the world for over 50 years. We work for a range of professionals within the construction industry, construction professionals, contractors, developers, investors, and importantly, their insurers. We provide a full construction project service. We have over 100 lawyers across the offices. I today am based in the City of London, but we also have offices in Bristol, Dublin, and the United Arab Emirates. Please, if you have an opportunity, take some time to visit our website, or indeed you could either contact myself, Joanne or Nathan, or any of the fellow partners. Next slide, please. Now, unfortunately, I'm sure that everyone is well aware of the tragedy that led to the current focus on building fire safety in the UK. Since Grenfell and the ensuing revelations about why they use combustible cladding, there's been the impetus and the focus for change within the UK. So today we're going to provide you firstly with a review of the legislative changes and consultations leading up to the draft Building Safety Bill, which I'm going to deal with. Then we're going to focus on the key aspects of the bill, as well as the omissions as well, because there are some, and Nathan will be dealing with that. And then we're going to go and look at perhaps some of the areas that should be within the bill, things that are coming over the horizon, and other key issues which are likely to arise later on once the bill has been passed. And Joe will be dealing with those. Next slide, please. So how did we get here? You all know, and most people here know, the Building Safety Bill was announced in the Queen's speech on the 19th of December 2019, with the purpose of putting in place a new and enhanced regulator regime for building safety and construction projects, as well as to ensure that residents have a stronger voice in the system. Nathan will be examining the bill in detail, but by way of introduction, I'm looking at this. How did we get here? How do we get where we are today? Now, most of you will be aware that Dame Judith Hackitt was commissioned by the government to assess the effectiveness of the current building and safety regulations in place at the time, related compliance and enforcement issues with a special focus on the high residential buildings with multi-occupancy. The initial review was released on the 18th of December 2017, with the full report being published in May 2018. I'll talk a bit more in detail about Hackitt's findings shortly. Now, following those recommendations, the government introduced changes to building regs, which resulted in the banning of combustible cladding in buildings over 18 metres high. The government then proceeded to further consultation as part of its consideration of general reforms within the building regs. This covered a number of areas, including the introduction of a system of duty holders and various mechanisms for keeping residents informed with a more effective regulatory and accountability framework. A bit more on that later. So this was the beginning of the reassessment of responsibilities and accountability, and an effort to ensure that risks are managed prior and throughout, as well as subsequent to building works. This also envisaged residents' engagement in this process, a system for keeping residents, tenants and leaseholders informed of the fire strategy and indeed building safety generally. The consultation itself extended in scope to beyond just high-rise buildings, but also looking at the situation regarding vulnerable people and just not limiting the regime to the height of buildings. Next slide, please. But subsequently, the approved document B was issued in August 2019, but like most things, have gone through a period of change. So there were subsequent corrections in September of that year, and indeed in May of last year as well. Basically, it sought clarification, and now Regulation 7 of building regs takes precedence over any other provision prohibiting the use of combustible materials and on the external walls of high-rise buildings. Any materials now used on external walls have to fall within European classification A1 or A2, and that applies to schools, care homes, hospitals, sheltered accommodation. Now, following that timeline, how do we get to where we are now? Subsequent to, and in fact contemporary to that approved document B revision, there was a government consultation on sprinklers and other fire safety measures. This again sought to review the height requirements for sprinklers, along with improving wayfinding measures and evacuation alert systems. At the end of last year in October, in the Queen's speech, it was confirmed that plans to implement the Hackitt proposals, including the position of a new building safety regulator and the imposition of criminal sanctions for non-compliance. There were a raft of recommendations in that Hackitt report, and it was said that all of them would be implemented. The fire safety bill was also introduced in March of last year, and this included an obligation on owners of all multi-occupated buildings to assess the risk of external walls. And for those who are interested, there's a webinar that was provided by Will Buckby and Ian Massell, which you can watch a recorded version on our website. The government also went on to announce additional funding to fund the removal and replacement of unsafe non-ACM cladding and further amendments to approval document B, and Joe's going to be talking a bit more about that. It was also at that stage that the government announced yet a further consultation with the National Fire Council. This was in relation to technology tests and also in relation to evacuation alert systems. Those reforms were all set out in a document called Building a Safer Future consultation document. And this envisioned a gateway system which involved providing information prior to the granting of planning permission, and then the submission of key information, including plans for fire and emergency response prior to occupation, as well as the provision of ongoing assessments. Next slide, please. So having looked at that timeline, where arises this so-called golden thread? And if I'm allowed to make a joke, that sounds something like an episode from His Dark Materials. Well, I mentioned I would return to the Hackitt report. The report itself was quite a damning verdict on the existing system of fire regulation. It concluded that regulation and guidance were not always read by those who needed to, and when they did, the guidance was often misunderstood and often misinterpreted. It was often unclear where responsibility lies, and that regulatory enforcement is inadequate, with enforcement often not being pursued, and in fact competence across the industry being patchy at best. Historically, fire regulation in the UK was divided into two separate phases: pre-construction regulation, which dealt with the planning process and approval of building design, and post-construction regulation, which covered the building occupation and use. Now, those flaws identified in the approach often meant that fire assessment had not been carried out or even been acted upon, and there was a lack of any specific requirements for competency for those carrying out fire risk assessment. Unfortunately, we then had Grenfell fire, which highlighted those flaws. So, Dame Judith Hackitt said, we now need this golden thread, which is going to pull together all of this information to help assess a better form of regulation for fire safety and building management. And now I'm going to pass on to Nathan, who's going to talk about the bill in more detail.
Thanks very much, Michael. Now, it has to be said at the outset of my section that although the bill itself is 331 pages long, it is actually fairly light on real detail. What it does do is establish a new framework for the regulation of building safety, which will be developed later through secondary legislation. Now, there are some criticisms of this, and also some criticisms in respect of what's not included in the bill. And as Michael said, Joe will come on to this in the next section. However, the majority of the detail that's available at the moment is contained within the extensive explanatory notes which accompany the bill. Now, the bill itself comprises of 5 main sections, which are up there on the slide. And in respect of those, Part 1 contains a very brief overview of the bill and states that the provisions of the bill are intended to secure the safety of people in or about buildings and to improve the safety of buildings. Part 2 establishes a new building safety regulator within the Health and Safety Executive. It also defines the scope of the new regime with respect to the definition of risks that it is intended to manage, and also creates the power to set secondary legislation in respect of the new regime throughout the design and construction phases, as well as during buildings' occupied life cycle. This section also contains the definition of building safety risk and higher risk building. Now, Part 3 of the bill is about the amendments to the Building Act as it currently applies in England. It sets out the provisions for the new regulatory regime during the design and construction phases of higher risk buildings. And it provides for the registration of building inspectors and building control approvers, and also improves the competence levels of building controls of the building control sector by way of better regulation. We won't be discussing Part 4 and Part 5 in detail, but just briefly, Part 4 concerns higher risk buildings when they're occupied and defines the duties of the accountable person, that is the duty holder during occupation, and the building safety managers in relation to the building safety risks in their buildings. As Michael touched on, Part 5 contains the supplementary and general provisions, which include powers to make provisions about construction products themselves and provisions about the regulation of architects. And as I said, the explanatory notes that accompany the bill provide most of the information in respect of those parts. Now, as Michael said, we won't have time to cover everything in the bill, but what we hope to do today is to highlight what we consider are the significant points for those involved in the design and construction of so-called higher risk buildings. So turning to slide number 8, the regulator and its functions. And the first major change is that a new building safety regulator is created under clause 2, and that is the Health and Safety Executive. Excuse me. Clause 3 sets out that the regulator has 3 broad functions. The first of those functions is to implement a new and more stringent regime for higher risk buildings. The second function is to oversee the safety and performance of all buildings. Now, this function has 2 key aspects. The first aspect is overseeing the performance of building control bodies, that is local authorities and registered approved inspectors who will become building control approvers. And this will involve monitoring the performance of these bodies and having the powers to impose sanctions for poor performance. The second aspect is understanding and advising on existing and emerging building safety risks, and advising on changes to the building regulations, and also the scope of the regime, and where necessary, commissioning advice on risks in the standard of buildings. The third function is to assist and encourage the competence amongst the built environment industry, and in particular registered building inspectors. This includes establishing and setting the strategic direction of an industry-led competence committee, carrying out research and analysis, and publishing advice and guidance. It also includes establishing a formal regime for architects' continuing professional development and competence to practice. It will also establish a unified body, a unified building control profession with competence requirements for registration as a building control professional, both in the public and private sector. In order to do this, the regulator is charged with a range of proactive duties, which include facilitating building safety in higher risk buildings and under clause 4, and keeping safety and standard of buildings under review in clause 5. Now, it's not on your screen, but clause 7 also makes provisions for consultation in respect of the building regulations. All of this provides the framework for the scope of the new regime so that the building safety regulator can manage building safety risks in higher risk buildings. Now, if we turn to slide number 9, building safety risks are defined in clause 16 of the bill. And what they're defined as is meaning a risk to safety of persons in or about a building arising from the occurrence of fire, structural failure, and any other prescribed matter. Now, this definition has been kept deliberately wide to provide for the scope to be developed. In terms of a higher risk building, this is defined in clause 19 as meaning a building of a prescribed description. Again, it's not very descriptive, and what the explanatory notes say is that the prescribed description will be subject to further legislation. Now, the notes do say that the prescribed description may be by way of a reference to a building size, design, use, purpose, or other characteristics. So again, it's quite a wide scope. If we turn now to slide number 10, the explanatory notes go a little bit further and suggest that for the time being, or at least for the first 2 years while the Act is in force, that the prescribed description will be as set out on slide 10 there. Once you've had a chance to read all that, just to distill it all down into simple terms, the initial prescribed description will cover all multi-occupied residential buildings with a height of 18 metres or more, or where there are more than 6 stories in height. And that height is measured, is continued to be measured under or in accordance with diagram D6 of approved document B. If we turn then to slide number 11, as I touched on earlier, the bill provides that the regulator will become the unified regulator of both building inspectors and what are currently known as approved inspectors. Now, what will this mean in practice? Well, it will mean that the building control, that those involved in building control, will need to be registered with the new regulator. There will be minimum requirements to be met in respect of those on the register, and there will also be requirements in respect of ongoing competence of those on the register. The regulator will also have the powers to impose sanctions in respect of poor performance. Turning then to slide number 12, we now look at the golden thread, duty holders and gateways. So there wasn't really room on that side, it's quite packed already, to set this out, but clause 36 sets out that the regulator will be the regulatory authority in respect of higher risk buildings. Any other work or any other work to a higher risk building. The local authority will remain the relevant regulator for non-higher risk buildings. Now, in some circumstances, i.e. a mixed development of both higher risk and non-higher risk buildings, it's stated in the explanatory notes that the building safety regulator may agree to be the authority for that development, but it's not automatic, and it's currently unclear as to how this will work in practice. What clause 37 does do is that it inserts provisions into Schedule 1 of the Building Act to create the basis of what will become the so-called golden thread. And I've put on the slide there some of these new provisions. I won't read all of them out, but for example, there will be new requirements on giving, obtaining, or keeping information or documents in relation to any work or matter to which building regulations apply, and that will be the new paragraph 1D of the schedule to the Building Act. Another one just to highlight is that the form and content of documents and information to be provided with building control applications will be specified under paragraph 1F. So while it's not a defined term, the aim of the golden thread is to ensure that high quality information in respect of higher risk buildings and safety is produced and retained so that that information is available to the relevant person at all stages of a building's life cycle. If we turn now to slide 13, to do this, the bill creates a new regime of duty holders across the life cycle of a higher risk building. Now, this is based on the principle that the person or entity that creates a building safety risk, remember back to that definition of what a building safety risk is, should, as far as possible, be responsible for managing that risk. Now, the duty holder roles apply when a building is designed, constructed, or refurbished, and therefore those involved in the commissioning, design, construction, or refurbishment process will now have formal responsibilities for compliance with building regulations. The duty holders mirror those appointed under the current CDM regulations, and the 5 main duty holder roles are up there on the slide with a short description of what they are and when they're responsible. Now, it's important to note that a duty holder role can be fulfilled by either an individual or an organisation or legal entity, and a duty holder can hold more than one role during a building project. The example given in the guidance is that a principal designer can also be a designer and will therefore have designer as well as principal designer duties. The bill also includes a general duty to govern the way that building work is carried out. And what the explanatory notes say about this is that it's to ensure that duty holders engage with the requirements and do not just see the regulations as a box ticking exercise. So how does this fit into the golden thread? Well, duty holders will be responsible for providing and maintaining fire and safety information about how the building was designed and built, which is to be stored electronically for the life cycle of the building, and they will be responsible for demonstrating that work was compliant with building regulations. If we can turn then to slide 14, the gateways. So the bill introduces a new gateway regime, the purpose of which is to ensure that building safety risks are considered at each stage of a building's design and construction. The regulator will oversee building work and ensure appropriate measures are being implemented to manage risk. So Gateway 1 is anticipated that this will be the existing process by which planning permission is granted in England. There will be secondary legislation and statutory guidance to allow this under the Planning Act. It is, however, envisaged that this gateway will occur before duty holders are required to be in place, and its requirements will therefore be fulfilled by those applying for planning permission where a development contains a higher risk building. Information will need to be submitted to the local planning authority to demonstrate that fire safety requirements have been considered in the form of a fire statement. Now, where a planning application is not currently required, for example, under permitted development rights, Planning Gateway 1 will not apply and the development will proceed straight to Gateway 2. The Gateway 2 is designed to bolster the current building control deposit of final plan stage, where a duty holder provides a building control body with their full design intent. The explanatory notes state that Gateway 2 should provide for a hard stop, where construction cannot begin until the regulator is satisfied that the duty holder's design meets the functional requirements of the building regulations and also does not contain any unrealistic safety management expectations. Duty holders will be required to submit key information to the regulator to demonstrate how the building, once built, will comply with the regulations. Design decisions in relation to fire and structural safety will therefore need to be well considered and justified to ensure that they will work effectively during the occupation of the building. There will also be a signed declaration form from the client to state that they have assessed and are content with the competence of the principal designer and the principal contractor at this stage. Now, turning to the final gateway, Gateway 3, this is obviously the pre-occupation of the building, and this is envisaged to be the current completion or final certificate phase. And this is where the work has been finished and the building control body then assesses whether the work has been done or carried out in accordance with the building regulations. All prescribed documents and information that comprise the golden thread at this stage must be handed over to the accountable person, and that accountable person is the person who will have responsibility once the building is occupied. Duty holders will be required to submit to the regulator prescribed documents and information on the final as-built building to demonstrate that building regulations have been complied with. Now turning to my last slide, which is slide number 15. Finally, the regulator will ensure compliance through a combination of toughened and new powers as shown there on the slide. The bill extends the time limits for sections 35 and 36 of the Building Act in respect of formal enforcement powers for non-compliance with building regulations. And both of those are extended to a 10-year period from 1 and 2 years respectively. In terms of the new powers, the regulator will be able to prosecute all offences under the bill and under the Building Act. And where an offence is committed by a corporate body with the consent or willingness of a director or manager, or is attributable to their neglect, that person will be liable to prosecution as well as the corporate body. The regulator will also be able to issue compliance and stop notices, and failure to comply with those notices will be a criminal offence, and the maximum punishment or the maximum penalty for those notices will be up to 2 years in prison or an unlimited fine. As I mentioned at the beginning of this section, a lot of the detail is yet to be determined, in respect of which I'll now hand over to Jo Lewis, who's going to talk about what is not covered and what is still to come.
Thanks, Nathan. Hi, everyone. So I'm going to talk about what's not covered and what is still to come by looking at 3 main things. One is the report from the Housing, Communities and Local Government Committee, which was the pre-legislative scrutiny that the bill has undergone. 2 is the Memorandum of Delegated Powers. I'm just going to have a look at a couple of those, which show what might be coming. And then 3 other issues which didn't make it into the summary of the key recommendations of the report, but I think are actually quite pertinent issues, particularly for the audience today. So the draft bill has been through a process of scrutiny, and this has resulted in 13 key recommendations, which I will go through to highlight the concerns over the contents of the draft bill in its current format. And I think by the time I've gone through those, you'll see there's quite a lot of work and clarification still to be done. The bill was also accompanied by this lengthy memorandum concerning the delegated powers associated. It gives a good idea of the further work that's foreseen to put the bill into practice with the various secondary legislation that's required, and what the government envisages for the evolution of building a safer future. To give you a sort of idea of it, the memorandum goes through 86 out of the 118 clauses where it says delegated powers will be required to bring in secondary legislation or official guidance, probably mostly from the Building Safety Regulator, to clarify, define and implement the measures in the bill as the new regime evolves. So it's safe to say there are a lot of gaps in the bill to be filled in by secondary legislation or guidance. One of the people giving evidence to the Housing, Communities and Local Government Committee had actually bothered to go through the bill and count it, and there are 569 references to regulations in the draft bill, which will be required to put in place in practice what's stated in the bill, and most of those don't yet exist. There is actually a lot of intention behind that. The government have confirmed that as far as they're concerned, it is a large and complex framework bill, and so it's appropriate to make use of secondary legislation to enable the Secretary of State to respond more effectively to changing circumstances rather than requiring amendments to primary legislation. And they say that that is for a number of reasons. For example, that until the Building Safety Regulator is fully established, there is strong justification for ensuring it has the ability to shape what they call the operationalisation, which is a bit of a mouthful, of the regime as it comes into force through secondary legislation. They also say that their understanding of the building safety risks will continue to evolve and improve over time, and so they want to ensure flexibility across the regulatory regime as this understanding develops. And that as the processes, structure and culture of the built environment industry continues to evolve, they need the flexibility to make changes to those systems. So I think it is clear that what the government expects from this bill and its intention is, as it committed to following the Hackitt report, a complete change in culture and practice in the industry. But it will take time to evolve. And so in their view, they struck the right balance in the draft bill of setting out the principles whilst allowing flexibility to evolve and refine what's required through secondary legislation. But where does that leave you and us in trying to interpret what exactly is required? On their own admission, over half of the secondary legislation required relates to setting out the procedures, the operational issues, the technical matters that will be required to operate the new regulatory regime. So where are the gaps and what are the concerns? As I said, can we go to the next slide, please, Chloe? First of all, I'm going to look at the key recommendations and concerns that came out of the Housing, Communities and Local Government Committee, because I think it gives you a good idea of the gaps in the bill and what needs to be covered that isn't in there already. It was published on the 24th of November 2020, and the government's response was due, well, it's stated to be due on the 24th of January, but that's actually a Sunday, so I think it probably will be the week after next, unless, of course, the current COVID crisis leads to a delay, which wouldn't be a surprise, I don't think. The committee received 430 written submissions and heard from 21 experts representing various stakeholders, such as the government, those from construction, insurance, fire and rescue, leaseholders, property management industry, and the HSC itself. And following that inquiry, it made 13 key recommendations, which highlight and represent the majority of the concerns arising out of the draft bill. So going through those in turn, the first one, and perhaps the most serious one, is the publication of more detail. The report of the committee recommends that the government includes as much detail in the bill itself, or that it publishes the secondary legislation alongside it, and that this is especially important for the core provisions, such as the gateway processes and the regulation of construction products. It does acknowledge the draft bill is a framework bill and that much of the detail should belong elsewhere, but that without sight of that secondary legislation, it's not possible to properly scrutinise its provisions, or for you and I to be prepared for the bill when it's enacted. Two of the key areas that are highlighted are the lack of definitions, such as the failure to define in the bill itself what a higher risk building is, and the lack of detail around the gateway processes. In regards to those gateway processes, a particular concern that was raised was around the timing of the appointment of the professionals in that process. Gateway 1 appears as currently drafted in the bill itself to be prior to the professional team being engaged, and yet it envisages having planning documents and a fire assessment ready at that stage. So the report goes on to recommend that the secondary legislation that will establish the gateway process actually mandates the appointment of duty holders before Gateway 1. What that means for you is likely to be earlier in involvement than perhaps traditionally, with those duties in mind at that early gateway. The second recommendation is a timetable. The committee recommended that the government publish with the bill a clear timetable for commencement, so that it's clear by when the industry has to demonstrate compliance and the building safety regulator has established the regime. The final bill establishes new duties, and some of them are extremely onerous on individuals and organisations responsible for building safety throughout the life cycle of higher risk buildings. And the committee did not think it right to expect individuals to implement its provisions and assume those responsibilities without sufficient transition periods. One of the key examples it gives is the safety case report, which is ultimately where all the information from the golden thread should end up. Quite rightly, they said it's difficult to know how to prepare for them when we don't know what's expected to be in them. There is no transition timetable at the moment. The London councils, in their submissions to the committee, recommended that it should be a 5-year period to allow for proper upskilling and capacity to service the demands of the bill. And we'll wait to see what the government response to that will be. The next recommendation was in relation to clarity on leaseholder payments. The committee felt the government must recommit to the principle that leaseholders should not pay anything towards the cost of remediating the historical building safety defects, and that they should get some peace of mind from the bill by the bill explicitly excluding historical costs from the building safety charge, which is bringing in. The fourth recommendation follows this on in relation specifically to the funding of historical defects, where the committee felt that the government must announce before it publishes the bill its proposals for funding all historical building safety remediation works, and that these proposals should impose no costs on leaseholders. They wanted it explicitly acknowledged that in the short term the government must foot the bill, and that until such time as mechanisms for cost recovery have been developed, that is the way they should go about it, and that they need to propose an alternative source of funding if they're not going to commit to it. They felt there were only two viable options: central government and industry. And it was the committee's view that however it does choose to fund the work, it should publish the proposals with the draft bill, because in their view, no future building safety regime can be adequate that doesn't also remedy historical defects. And I know it was announced just at the end of the year that the applications for the Building Safety Fund have now been extended. Whether more money will go into the pot is to be seen. Perhaps of more, sorry, can we be on the next slide? Thank you. Perhaps of more interest to you is recommendations 5 and 6, which is in relation to the scope of the bill. Recommendation 5 is that the initial scope of the regime be enshrined in the bill itself and not be left to delegated legislation, in order to give the stakeholders the certainty they need to prepare for the new regime. The new regulatory regime will apply to higher risk buildings, and yet, as we've already seen, the definition of those buildings is missing from the draft bill itself, being left instead to the explanatory notes. So therefore only stating the government's intention, not actual law. By properly defining the central pillar of the new regime in the bill itself, the government will give duty holders the certainty they need to prepare for implementation and ease the transition to compliance. There's also some discussion in the report around the definition of building safety risk, which at the moment is limited to fire and structural issues. There were lots of submissions made to include electrical and gas risks in particular, but the committee did not make a recommendation to widen the definition at this stage, as they felt that given fire would be the main rapid onset event arising from an electrical gas failure, these are probably already caught in the current understanding of what is meant by building safety risk. They have asked, though, that this issue is dealt with in the guidance to provide clarity around the definition of building safety risk. And looking at the expansion of that scope, which is clearly envisaged in the bill itself, it was recommended that the government specify in the bill, by way of a requirement to have regard, the factors that must be considered in the future when the scope of the regime is expanded, and that the ability of residents to evacuate a building should be a principal factor. They felt that any requirement to have regard to the ability of residents to evacuate a building explicitly include the vulnerability of residents and the numbers of means of egress. So essentially they want to see a commitment in the bill itself to including, at a specified point in the future, other risk factors, particularly the vulnerability of residents and their ability to evacuate the building, and that this would demonstrate the determination to improve the safety of all higher risk buildings. The types of buildings that should be included relate to buildings that hold vulnerable people. AXA made quite lengthy submissions on this, in referencing hospitals, hospices, care homes, and there were also calls for the scope to include all buildings built using modern methods of construction. So buildings built with modern methods of construction should come under higher risk buildings. And that last comment is something that the report has urged the government to keep under review. So is applying some pressure to include that in the future definition. So the report recommended that the government indicates its intention to review the scope and sets a timetable for doing so. We have the next slide, please. So the next recommendation is in relation to third-party accreditation. The report stated, "It seems to us that few measures are more important to raising levels of industry competence than a system of third-party accreditation and registration for design and construction professionals." So it's strongly recommended that the government include provisions in the bill itself for establishing a national system of third-party accreditation and registration for all professionals working on the design and construction of high-risk buildings. But it did not go into details about how to do this, and but it did note that the submissions they received also didn't really give any ideas as to how the bill could be amended to facilitate this, how it would fit in with the accreditation that professionals already have to have, and what the mechanism and requirements for achieving that third-party accreditation would be. So we need to wait and see what the government's response to that is. But there certainly is pressure for all those professionals involved in design and construction to have third-party accreditation. The eighth recommendation is in relation to building control bodies. As Michael touched on, the Hackitt report identified that the ability of duty holders to choose their own building control body and the consequent conflict of interest that can result is a major weakness of the current building control regime. The criticism is that the draft bill only removes duty holder choice from building work on higher risk buildings, which is not the vast majority of building work. And there were plenty of submissions on this point, such that the committee has concluded in its report that duty holder choice should be removed entirely from the building control system and be replaced by a system of independent appointment, and that this is made explicit in the bill or in the secondary legislation to be published alongside. The next two recommendations really relate to accountable persons, so I'll just deal with them very quickly. The draft bill provides that owners of high-risk buildings to be appointed as accountable persons. Some buildings, however, depending on their ownership structure, will have multiple accountable persons, which could result in confusion over where responsibility lies. So the report recommends that the bill provide for a general duty to cooperate on accountable persons in respect of buildings for which there are multiple accountable persons, and that the government publish statutory guidance alongside the bill, setting out the sorts of behaviours that would be expected under such a duty. An example of that they give is if you have for example, where I live, where we are leaseholders with common parts, the common parts of the accountable person may be the management committee as well as the leaseholders. So they want a duty to cooperate. The 10th recommendation is statutory guidance for accountable persons, and this is looking and not only providing the guidance in terms of the duty to cooperate and what was expected under such a duty, but also looks at the fact that the accountable person's role is similar to the responsible person established under the Regulatory Reform Fire Safety Order 2005. And the committee felt that instead of rationalising building safety legislation, in this instance, the government has chosen to add an extra layer which could result in overlapping responsibilities and consequent confusion. It recommended that in the short term, the government publish statutory guidance alongside the bill outlining how it expects accountable persons and responsible persons to cooperate in practice, but that in the longer term, it recommended that the government review the operation of the two regimes with a view to rationalising and simplifying the legislation. It also addressed an issue around accountable persons' duty to prevent a major incident, which is clause 73 of the bill, and noted concerns that there's a lack of sufficient clarity around the definition of a major incident, and called for statutory guidance on what steps an accountable person should take to provide one. And it's just to prevent one, sorry. And it's just another example of the lack of definition in the bill itself. Recommendation 11 is in relation to the competency of building safety managers. Accountable persons are required to appoint a building safety manager to oversee the day-to-day management of building safety risks. This is an entirely new profession created by the bill, and one that will be crucial to the success of the new regime. It's envisaged that building safety managers will be highly trained and competent people, and the government expert panel, Working Group 8, drew up a proposed competence framework for the role of the building safety manager, but it's not yet been confirmed if that is the framework that will be adopted for the building safety managers. And so it's difficult at the moment to see how the industry can begin to recruit and train people to fill these roles without citing the competencies required. And the committee felt that if the government did not produce them soon, the implementation of the new regime could be impeded. So they therefore recommend that the government announce before the bill is published whether it intends to adopt the competency framework for the role of building safety manager that was proposed in the report from Working Group 8, and that if it doesn't, it must publish with the bill the full details of the framework it intends to adopt. And alongside that is accreditation for building safety managers, which is recommendation 12. which essentially acknowledges how critical these building safety managers will be, and that a robust system of accreditation and registration will give accountable persons and residents confidence in the competence of those appointed to do that role. And so the committee recommended that a national system of accreditation to agree common standards and for a central register of building safety managers be provided. And the last of these key recommendations is product certification. The Hackitt report had found that product testing regime was opaque and that greater transparency was required, as Michael touched on. But whilst the draft bill includes provisions for regulating construction products, it, as a common theme arising, contains little detail, especially on the future testing regime. And it was felt that only by requiring the publication of test results and by providing third-party certification that real transparency could be achieved. The report therefore recommends that the government provide for the publication of test failures and rerun tests, and for the establishment of an independent and unified system of third-party certification in order to introduce greater transparency and rigour into the regulation of construction products. It also talked about the need for testing of products in combination and in isolation, and gave fire doors as an example, whereby components are tested in combination but then procured individually, and so there are the risks around changes to individual parts which might affect the integrity of the whole door are not necessarily caught in the testing certificates. Therefore, the report recommends that the government make provision, either in the bill or in the secondary legislation, for a testing regime that treats products as part of the system, but also individually, perhaps by mandating the provision of a certificate confirming how the product performs when combined with other products. It also makes a recommendation in respect of how products with more than one application are to be treated. So, for example, cables, which in some circumstances would fall under the safety critical product definition, but in other circumstances wouldn't. So it wants a recommendation as to how those sorts of products are to be treated. I think given the evidence that we've heard in the Grenfell inquiry recently, and the focus on certification and testing and how reliable those certificates are, we do anticipate that the bill will want to look at the product certification issues in more detail, which also brings me on to another point about how it's unclear how the recommendations that will come out of the Grenfell inquiry phase 2 report will be adopted, and whether they will lead to amendment to this primary legislation or will be dealt with further secondary legislation or statutory guidance. Can we have the next slide, please? So trying to see where the government itself is looking to expand or change or amend the bill in the future. I mentioned at the beginning the memorandum on delegated powers, which is a guide as to where the government's indicated what will be coming in the future and what provisions it's made for delegated powers to evolve this building safety bill. As I explained, there are 86 clauses where further guidance and or secondary legislation is expected. A lot of them will deal with some of the points that have come out of those recommendations in due course. The recommendations obviously want them to come into the bill itself, but they are covered for in the delegated powers in the main. I've just picked out a few to highlight. One is the meaning of building safety risk, which is clause 16, where it's clear from that there is going to be an increase to the scope further and wider than just fire and structural risks, which is what's coming at the beginning. Secondly, the meaning of high risk building, which is clause 19. As Nathan said, this includes a power to define the meaning of a higher risk, and that power is broad. It allows buildings to be described by reference to height, size, design, use, purpose, or other characteristics. But what the delegated powers memorandum has done is that in relation to certain kinds of higher risk buildings, it allows the scope for only some parts of the regulatory regime to apply to some types of higher risk buildings. So the example is if the bill evolves and that definition evolves to include, for example, tall office blocks, it may be considered that it's not appropriate due to the nature of the occupants to apply the residential engagement requirements to those tall office blocks. And therefore this clause could be used to switch off that requirement. So they are trying to allow an evolution whereby the primary legislation wouldn't need to change, but they can make caveats and carve-outs by the use of these delegated powers. Clause 33.1, which is fees and charges, also has a delegated power to allow the building safety regulator to levy charges and fees in connection with its functions in Part 2 of the bill, which includes the regulator's general functions. and Part 4, which is regulating the high risk buildings and occupation. And also in relation to Clause 11, the new Clause 11A of the Health and Safety at Work Act 1974. And I think this is of note both in terms of cost and insurance cover for those involved. Those that have been involved in HSE investigations and have been subject to the introduction of the fees for intervention will know that those fees can escalate quickly. They're often not covered by your insurance and can be extremely difficult to challenge. So that is something also to bear in mind, that's not explicitly set out in the bill but is coming. And finally, interpretation of Part 2, Clause 35, 1 and 3, which allows for the definition of the building to be expanded to for example, non-residential buildings. But there is, again, a delegated power to allow for specific types of building to be excluded. And the example given is in relation to a building at a nuclear facility, whereby such installations are subject to their own safety regulatory regime, and so they could be carved out from this regime. But that does touch on one of the issues with the bill, which is the overlapping legislation and overlapping regulatory regimes and potential conflicts with them. Which brings me happily onto my last slide, which is the other key issues. And I think one of them is the interactions with other regulations, and in particular the construction design and management regulations and the fire safety order. The Housing Communities report specifically noted issues with this, and in particular in relation to the principal designer role. And it's recommended that the government needs to work with industry to identify and resolve potential confusion, and recommends that the role be defined in secondary legislation to be published at the same time as the bill. Because if you saw from Nathan's slide going through the duty holders, they mirror the CDM duty holders, but they have different requirements. So there is a lot of potential there for confusion. There's also, I think, potential for people to follow one thinking that will make them comply with the other and vice versa. There are also other areas of potential confusion, such as the contents of the safety case report. What information is required to be in it? Can it simply adopt, for example, the health and safety file? What if the client who gets the health and safety file is different from the accountable person who has to produce the safety case report? What duties to those who compile information for one, which is also used in the other area? And coupled with that, what liability may be taken? All unanswered issues to be established in due course. The next one is training and establishing competency for the new roles, but also for everyone to be able to comply with the new regime. This will take time, and I don't think it can be rushed. How is it going to be achieved? How it's going to be achieved is an unanswered question, but it will be key in demonstrating compliance with the bill, and demonstrating it will be central to getting appointed to projects, to defending investigations from the regulator, in defending liability claims, and I think probably from getting insurance for your business. Issues around how the reasonably competent person in each discipline will be expected to act, and what they might be expected to know about other disciplines if they're involved in certification at the gateway process. The third issue I have there is the HSE. They are being asked to take on a role with numerous facets, and not all of those are complementary. This was an issue that came up in the committee's investigations, and the report found that the majority favoured the HSE as the building regulator, and so has chosen not to make a recommendation against it. I do share some of their concerns, though, having experienced the HSE and the way in which they approach health and safety investigations and risks. The report makes a recommendation that the government should provide clear justification for combining in one body both the regulation of the industry and decision-making in relation to the regime. They did not find the HSE's response given in evidence that they will have the right kind of Chinese walls in place as very reassuring. I think our experience has shown that there will need to be some education around construction projects and how they work in practice and the different types within the HSE. One of the bugbears that I have with the CDM regulations is they're really more suited to traditional contracts and not so suited to the design and build type of contract, where there aren't necessarily distinct phases of design followed by construction, and the development of design moves through different parties, which can make navigating the duty holders' responsibilities under the regulations difficult. And yet, my experience shows the HSE have a tendency to approach these things in a very linear way, and we all know that's not how construction projects often run. And so I think there is a concern that this building safety bill may run into the same problems within the HSE's understanding of how the projects run, how phases merge into other phases. The fourth one I have there is insurance. Obviously, as we've heard, there is so little definition around the scope, remit and role under the new regime. So much of it is unknown, and therefore it's difficult for underwriters to understand what risks they may be covering. The certification at gateways of multidisciplines. How do you demonstrate the competency to do this without a proper definition of what's required by the bill? And it's not clear what insurers would expect in terms of whether you're competent to do that. It should be noted that in the submissions to the committee, the International Underwriting Association, in its evidence to the committee, called for mandatory third-party certification for construction firms to show their accreditation and give insurers greater confidence. So it clearly is going to be a key issue for policy underwriters. There's the new roles, the accountable person and the building safety manager, and evidence was given to the report about the fact that the market is already extremely hard, and that this bill will widen the scope of insurance required in the design and construction industry. The message being certainty is required on the roles and responsibilities and accountability to enable the insurance industry to respond. The report therefore recommends, although it doesn't make it one of its key recommendations, that the government consult further with the insurance industry and only introduces the bill when it can A, publish for simultaneous consideration draft building regulations showing how it will exercise its powers under clause 38, which is the duty holders and general duties clause, and B, has commissioned an evaluation of the availability of adequate insurance for all duty holders and reported accordingly to Parliament. And the last one is just costs. I just wanted to put that up there because obviously there's going to be a lot of costs, not only in terms of increased costs to projects, because I think it's clear that different parties are going to have to be involved at different bits of the process, and maybe earlier and longer engagement and more engagement with client and with future occupiers of the building. But also internal costs in terms of adapting policies, procedures and training, and getting the relevant insurance in order to make sure that you can comply with the requirements of the bill. As I think is clear from the talk so far, there's a lot of good intention in the bill, but there is quite a lot missing in terms of clarity and actually what is going to be required in practice. And I will hand over to Michael just to conclude. Thank you.
Thank you, Joe. Just to perhaps just try to bring a few things together. It's apparent that the draft bill could dramatically improve building safety, but obviously there remain a number of concerns about the provisions, particularly in respect of the lack of detail and the dependence on secondary legislation. Whilst it's attractive that the current drafting leaves room for change and flexibility, what is unattractive is the fact that so much of the bill needs to be completed. As a personal view, the digital golden thread, I think, is unlikely to be a panacea, as competency remains the core issue, and that needs to be addressed. The most important factor when carrying out fire risk is, of course, competency and the assessment and management of building fire safety. It's obvious that the digital golden thread envisaged a BIM approach, and we all know about the issues around BIM, building information modelling, the fact that it promotes a real challenge because there is patchy investment across the industry and there's limited technical capacity. So what next? You'll see that the bill will be formally laid before Parliament early 2021. In fact, I think it's envisaged in late February, March. But please be aware, of course, that the government's going to respond to the consultation probably next week. And Nathan, Joe and myself will produce a paper in relation to that. The idea being that the new regime, of course, comes in place in 2023. However, what's clear is the fact that new practices need to be implemented as soon as possible. Why? Well, firstly, because of course the bill envisages new professions and new responsibilities. And that's going to be of concern to the industry and obviously also to insurers. The golden thread is of course going to be digital, and that's going to produce, I think, further concerns about the ability for the construction industry to deal with digitalisation generally. And thirdly, of course, the introduction of a new testing regime. Again, we know little about that, but of course that means that steps need to be taken down to envisage that. Now, unfortunately, we're running over time, so we don't have time for questions. But if you could just throw the last slide, please. I would like to just tell you about the next upcoming webinar, which is going to be provided by Will Buckby and Associate Robert Reed. Particularly a bit of interest to people on this webinar, because it's going to be discussing the hardening contractual and insurance markets. So that will be of interest. So please, if it is of interest, register either by sending an email to the 2 emails on the slide or by contacting Joe, Nathan, or myself. So all that remains really is for me to say thank you for joining us this afternoon. Stay safe and enjoy the rest of the day. Thank you.